The case started with a beef between an individual and their local post office. Respondent Labine Conan and the local post office in Euless, Texas, had an extended dispute concerning mail delivery to two rental properties owned by Conan. The dispute basically came down to who owned the property and who was eligible to receive mail at the two addresses owned by Ms. Conan. According to Ms. Conan, how the U.S. Postal Service handled the complaint led to serious consequences for her and her tenants. As a result, Conan and her tenants did not receive important mail. Conan resorted to private carriers. The disruption in mail service resulted in the loss of tenants and made it more difficult for Conan to attract new tenants. The carrier also taped a red notice inside the mailbox stating that mail addressed to some but not all of the Saratoga residents could be delivered to the box. In 2021, postal workers also allegedly stopped delivering mail to the Trenton house after discovering Conan owned it as well. Ms. Conan did what most people would do. She filed a complaint with the Postal Service. However, that did not get her the results she wanted. After administrative complaints proved unsuccessful, Conan sued the United States in federal court, bringing various state law tort claims alleging that the United States Postal Service intentionally and wrongfully withheld her mail. As with most federal suits, the first stop was a district court. The district court dismissed Conan's complaint pursuant to the Federal Tort Claims Act's postal exception, under which the United States retains sovereign immunity for all claims arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. The district court claimed the United States has sovereign immunity. I'll cover that more in a later chapter. The court also noted that Congress provided that the ability to sue did not include cases involving the non-delivery of mail. The provisions of this chapter and Section 1346B of this title shall not apply to any claim arising out of the loss, miscarriage, or negligent transmission of letters or postal matter. Don't you love it when the government writes laws exempting itself from its own negligence? Now, the Fifth Circuit Court of Appeals disagreed. The Fifth Circuit reversed, holding that the terms loss, miscarriage, and negligent transmission do not encompass the intentional act of not delivering the mail at all. The Fifth Circuit apparently thinks that negligent acts are not intentional. However, the Fifth Circuit disagreed with the First and Second Circuits, which led to the Supreme Court case. In contrast, the First and Second Circuits have interpreted the postal exception to apply to suits even when they arise from harms caused by intentional misconduct. The court granted certiorari to resolve the split. So, how did the Supreme Court view this case? Well, they held the United States retains sovereign immunity for claims arising out of the intentional non-delivery of mail because both miscarriage and loss of mail under FTCA's postal exception can occur as a result of the Postal Service's intentional failure to deliver the mail. Well, there are a couple constitutional issues with this decision.